think we're good.
Good. Okay. Thanks. I didn't see it yet, but okay. All right. So good afternoon. I'm Delegate Pam Queen. Welcome to the Banking, Consumer Protection and Commercial Law Subcommittee meeting. Today is March the 7th. So we have a couple bills that we need to welcome to the Banking, Consumer Protection and Commercial Law to do today. And so I'm going to let Tiffany start with the first bill.
Okay, so can everyone hear me? We're good?
Excuse me, Madam Chair, there's an echo or feedback coming somewhere. If we can figure out where that is, maybe everyone can go on mute.
I think it was me. Are we okay now?
Okay, is there an
Yes.
echo when I speak? Okay, I'll start now. All right, so we have HB 282, financial institutions, mortgage loan originators, independent contractors. This is Delegate Queen's bill, and the bill alters provisions of law relating to the licensing of mortgage loan originators to generally require the licensing of independent contractors as mortgage loan originators instead of as mortgage lenders as required by the law currently. An independent contractor may be issued a license and act as a mortgage loan originator only if the independent contractor is not engaged by more than one sponsor in the state.
What was that bill number again? I'm sorry.
This is
Madam
House
Chair.
Bill 282.
282. Okay, got you. I just had a 2. Okay. I got it.
Madam Chair, are you looking for a motion?
Move favorable.
Yes, looking for a motion.
Move favorable.
Second.
Okay, are we gonna do a roll call? Okay, Delegate Adams,
Yes.
Delegate Amprey,
Yes.
Delegate Harrison,
Yes.
Delegate Rogers,
Yes.
Delegate Rose,
Yes.
Delegate Turner,
Yes.
and Delegate Weibel is not here. Delegate Queen, do you want to vote? No? Okay. All right, that bill passes the subcommittee. The next bill is House Bill 400, Commercial Law Ability to Pay Verification Exemption. This is Delegate Kipke's bill. And this bill exempts mortgage loans made by community development financial institutions from certain requirements to verify a borrower's ability to repay the loan. Yeah. Delegate Queen, did you have something to say about this bill?
Madam Chair.
Yes.
Okay, no amendments to this bill here?
No.
No amendments. Okay.
No, I thought Delegate Queen, you said there was some concern that was raised about this bill in relation to your other bill. Can you hear me, Delegate Queen? I think we're having some technical difficulties.
She's not talking to me.
Correct. So it looks like a bill we had a couple years ago. It was one of the speaker's bill, and some of these issues that were raised about, especially related to the ratios that could be that were acceptable was problematic. So I think we want to look into this some more and see if we can even do this, or will we have the same sort of issues raised before. So, but I wanted to make sure you were aware of why we were, what concerns were raised.
Okay.
What were the concerns?
If you look at the testimony, we had one unfavorable that really talks to the issue of not of allowing mortgage owners to go below the debt to ratio, the debt ratio, that debt ratio that's kind of set by Fannie Mae about what's appropriate for going forward with a mortgage, that is something we typically don't want to do. And so I think that's the same concerns we heard when we heard this type of bill a couple of years ago. So I don't know if we want to go and allow mortgage lenders to not be at that debt to income ratio.
May I, I know that back in the 2000s, late 90s, there was some relaxing of the application parameters and who qualifies, who doesn't. And in a lot of cases, the problems were they did no document loans, and their lending standards were also exceedingly low. And I say exceedingly, I mean well beyond the pale, because the market was either demanding it, the government was supporting it, or et cetera. This bill appears to be only talking about one element of that. So there's still, you have to prove your income, you have to do a lot of things. But for first-time home buyers and people that are trying to get into a home ownership situation, the bill appears to be narrowly discussing one component that relates to the transaction. And I don't see how it takes away from the mortgage company's ability to make a decision. What it's trying to do is relax their restrictions on this one component. I think that's the difference between what happened in 2008, which was the mortgage-backed security crisis, where it was a free-for-all with the banks. Literally, they could care less whether or not you had enough money to pay the mortgage. They were basically saying yes to everybody, and that created the free fall in the market that, frankly, I think we're still dealing with in some regard. But just understand that there are a lot of people that can't be homeowners because of this one issue. And I think that the bill is, whether or not it's legal and whether or not it's something where committee council needs to go back and see whether we can even do this, I would just say on basis, we should be encouraging people to get into a home ownership position if they can afford it, right? If they have the income to produce it, and maybe, they can't come up with the down payment, or there's a debt to equity number. So my 2 cents.
I had a question or a comment as well. Just to echo off of, I agree with a lot that Chris just mentioned. And what I recall about this hearing, and what I liked is when you're going back to putting the human element in the underwriting process and having that flexibility to look, holistically at the whole application and the situation that the borrower is in, I think makes sense. Because, just because there's one particular number, there's compensating factors. There's a way to address, that particular concern. And I think just having it be such an automated, hard and fast number takes away that flexibility and the way to look at a loan and say, this makes sense. These people are going to be able to afford this home, rather than just being stuck to that particular number. So that's just my 2 cents on it. I like the bill. So thank you.
There is, sorry.
I think Delegate Rogers has a question.
Thank you, Madam Chair. I, just kind of listened to the comments, some of the comments from Delegate Adams and reading some of the testimony. Is this something we might want to hold and come back to so that we can kind of work out what some of the questions were?
I'm okay with that, Delegate Rogers, as well, as one that was talking in support. I'd want to know if there's some legitimate concerns.
Yeah, I think we may want to look at this because one of the things that we changed with the bill, that was just passed 2 years ago. So I know the issues that happened in 2008. But one of the things we did outline then was that there were ways that homeowners or potential homeowners could address some of their concerns by having other methods of evaluating their credit worthiness. And so I think we kind of talked to this without lowering that ratio. So let's look at this some more and come back to it. I think would be the best course of action.
All right, so we're holding HB 400. And the next bill is HB 1150, Commercial Law and Financial Institutions, Credit Regulation, Shared Appreciation Agreements. So this bill makes shared appreciation agreements subject to the Maryland Mortgage Lender Law and other provisions of law that regulate loans of single extensions of closed-end credit and revolving credit plans. Any entity engaged with giving out shared appreciation agreements is subject to the regulatory authority of the Office of the Commissioner of Financial Regulation. And the Office of Commissioner of Financial Regulation is authorized to adopt regulations regarding enforcement and compliance.
Council, can you talk to the Attorney General's letter of information on the bill?
Yeah, so hold on one second. They said, so I think what their concern was that by licensing these shared appreciation agreements, because they're not currently licensed, by explicitly licensing them, they can be predatory. And I think they're saying that maybe that's saying that they're okay. But I think that's what the Attorney General their letter of information was saying.
All right, thank you.
Yeah, they also said, hold on one second, I'm sorry. They also said the Consumer Protection Division notes that these loans are currently subject to Maryland's laws governing lending mortgages and predatory practices, whether or not they're identified or not. But I think that was their concern, that it might be legitimizing something even though they're already subject to it.
Did the Commissioner on Financial Regulations, didn't he testify on this bill?
Mm-hmm. Yeah, this is their bill, and I thought the reason why they wanted to make sure it was licensed is that they could address any of the issues that could be predatory. That's putting them under their umbrella to be able to do enforcement. So that's the reason for their bill. This is their bill.
Move favorable.
Any seconds?
I have to get off of mute. Second.
Okay,
Okay.
we're gonna do a roll call now.
Yeah.
Delegate Adams,
Yes.
Delegate Amprey,
Yes.
Delegate Harrison,
Yes.
Delegate Rogers,
Yes.
Delegate Rose,
Yes.
Delegate Turner,
Yes.
and Delegate Weibel is absent. All right, those are all the bills for today, Madam Chair.
Well, thank you guys for the time. It wasn't a heavy load today, but the chairman thought it was important that we talk. Yes, Delegate Rogers.
Was there one more bill or did that one get pushed?
That one got pushed.
Got it. I know I saw 4, but okay, no
Yeah,
problem.
but we will look at that next time. So
Okay.
thank you for your time, and we will follow up on both of those bills. Have a good afternoon and appreciate your
Thank
input.
you.
Bye-bye.